Hello, this is Tom Hutchinson. I'm the instructor for Bethel University course on legal issues in higher education. That's course number EDUC 862. And this video is designed to give my views as to some context and some uh, things I hope you as students have gleaned from the course as you complete your time now studying these issues. So the first thing I think we can all agree upon is that the amount of material that you are asked to look at is quite massive. The takeaway is obvious that the legal system now touches almost every aspect of higher education. And consequently, because of that huge uh, involvement of legal regulation and case law and state and federal statutory law, it's impossible for anyone to be a subject matter expert on more than a fraction of that material. So the course is not designed to make you subject matter experts. It's simply to expose you to that material so that you will understand how comprehensive the legal system is when it approaches the law of higher education. And to quote our old friend Donald Rumsfeld, it's to help you know what you don't know, right? So that you will understand that no matter what the issue is that's facing you, and no matter what your capacity is in your higher education institution, that there's likely a legal dimension, and it's to your advantage to find what that legal dimension is and understand it before you make any significant decisions. So you want to understand that there is so much to know that you can't master it all. The corollary to that is you can know some of the subject matter that touches your specific responsibilities. And the way you go about mastering that is to do just general reading, check in with your professional organizations that you might be involved with. So if you're in student life, there are student life organizations. If you're in finance, there are financial support organizations, all of whom will help lead you or make you understand what courses of legal thought are out there that might assist you in understanding what you need to know for your niche. Okay, higher up the ladder, you might have to know more and more general knowledge, but for most of you, knowing your particular niche will be enough. And I noticed that in the papers that you've submitted, you tend to, of course, uh, submit topics that are near and dear to your heart. So if you're involved with student life, you write about students. If you're involved in some other dimensions such as faculty, academic freedom might be your topic. So you can't know it all, but you can know the hot button topics and issues for your area of expertise. And that's what you should concentrate on. You also have learned something about the legal system, which I think is very helpful for you and to can kind of guide you as you try to decide what sources are most important. I think you've learned that we've got both state and federal uh, systems involved, but for most of higher ed, frankly, the federal system is the dominant one. The state regulation is important in certain areas, it may add some dimensions to what you need to know, but really federal law tends to be where most of the important issues reside. And that's for one important reason, and that is because federal student aid is so critical to the financial success of all institutions, public and private. And with that aid comes the right to impose requirements. And that's why the federal law and federal regulation tends to be most prominent. So keep that in mind, and keep in mind also when you're looking at those systems, how important precedent is. Uh, you want to know when you're approaching a situation, remembering, are you a public or private institution? Separate rules might apply. Precedents within your organization are very important. They're often overlooked, but it's important for the institution to have internal consistency. So it does matter what the institution has done in prior situations that have similar fact patterns. So internal precedent is important. External precedent, by that I mean cases that have been decided either in the courts or by regulatory bodies. Those can be very important, very instructive, and they will help you gauge the risk of what consequences might ensue if you pursue one course versus another. The last precedent out there is peer group schools. I think that can be very instructive and is often overlooked, at least by lawyers. You need to see what are your brother and sister institutions doing in similar circumstances. It can be very helpful. If you have contacts in those institutions, you can call up your opposite number and talk about it, or again, professional organizations, or just look up what's going on their websites. It's nice to know what's Harvard done with this issue of academic freedom, for example, or what are, if you're a member of the CCCU schools organization, what are your fellow members doing with those issues? What are they doing on Title IX? How many have opted for an exemption, for example, from Title IX? Why? Why not? So those precedents out there can be very helpful to you. So never overlook that. That should be the way that you educate yourself as to these various issues. So one of the major things that I hope you've learned by the exposure to some of these topics is you can't know it all. You can only be a subject matter expert on very tiny portions, but I hope you've learned a little bit about how lawyers think, and that one of the major takeaways should be learning to spot the issues as they are coming into focus in any particular situation. That is really what this is all about. You need to know that the issues exist and what the major premises are so that you can navigate in a system that has a lot of trapdoors that can get you into trouble. So by spotting issues, what I mean is when you see a scenario with a student, you're thinking about due process, you're thinking about the student's expectations, you're thinking about the parents' expectations. And because you are doing that, you'll be able to anticipate the problems and be able to meet them head on and not be blindsided. There's an old story I've sometimes told about taking the bar exam. I was young and took the bar exam. We had 12 questions that we were to answer. They're all essays, of course. And they did not tell us what the question was about. It wasn't said, it wasn't labeled. So you'd read the fact scenario and you decide, all right, this is the contract question. And an old lawyer once told me, always remember, put at the top of your answer, this is the contract question, right? That's the issue. We're looking at contract issues. Don't put, this is the constitutional law question. Because at least if you identify as the contract question, even if you blow everything else in the answer, the reader will know, well, at least you got that much, and you'll get a little partial credit. Same here. Know the issues, be able to identify them, and that will put you on the right track. Everything else really is due diligence, learning what the minutiae is in the cases, in the precedents that are out there, and what your sister and brother schools are doing. But if you don't know the issues, you're lost, and you'll have no choice but to probably overuse legal counsel. You want to know the issues yourself before, so you know what questions to ask. and how important it is so that you are using the resources of your institution wisely. The other thing that takeaway I hope you've gotten from this course is that the facts of every situation drive the analysis of legal principles. And you are in a position as educational professionals, if you are involved in an early stage of a developing situation, to actually form the facts before they become static and the attorneys need to get involved. By that I mean, if, for example, you're involved in an investigation of, say, a misconduct of some kind by faculty or a student or anyone else, I've had the situation arise where someone's called me and said, well, we found these allegations and they look like they have some truth to them, and we're thinking about moving forward. And the first question I ask is, did you talk to the person that is alleged to have done these acts? Did you get their side of the story? And I was shocked to find out how many times the answer was, well, no, we didn't get that far. No, we're waiting on that. We wanted to talk to you first. It's important to always fill the gaps, because if you take precipitous action without getting all sides of the story, for example, you don't have much of a chance if someone then accuses you of not following due process. A chance to be heard, a chance to talk to the issue is what everyone expects at a minimum. So keep that in mind. You have an opportunity, because of your placement within the institution, to still affect the outcome by making sure your factual investigation has got fairness attached to it. The final thing I want to mention to you is, obviously, the legal system is an adversary system. We talk about plaintiffs and defendants, or claimants and respondents. It's all very much based on the model of one side wins, the other side loses. And the facts are very important, and then how you argue the law is very important. But that is not necessarily a good model for handling problems within the institution that you serve. That's why alternative dispute resolution, the so-called ADR, should be looked at. Other reconciliation devices or restitution or resolution conflict techniques can be very important. You do not want your university or college to be a mirror image of the legal system, because that is totally inefficient and does not serve your mission of pedagogic advancement of the subjects that are near and dear to your faculty, and your overall mission of instruction. And if you have a religious mission, that mission as well. None of that is compatible with an adversary system. So you should only be looking at using the adversary system, in my view, as the legal system, as a last resort. So make sure that if you have the opportunity to be involved in those situations with your college or university, that you advocate for preventive measures, and if there is a dispute, for alternative dispute resolution measures. Because if you go through that practice and you go through those steps, you'll find that, in my experience, has been that about 80 or 90% of the legal questions are resolved. Maybe not to everybody's satisfaction, but you reach a consensus where everyone can say, all right, well, we've learned some things, we'd like to do some things different, and we can go forward. So use that model rather than the strict adversarial model that we see in the law. And I think that's a good place for you to land. I hope that this has been a helpful course to you in understanding the place of the law in higher education. And I wish you well in your future careers, and I look forward to hearing good things about all of you.